For being here with us. This is the 11th annual Court Symposium of the Historical Society for the Southern District of Indiana. My name is Daniel Pulliam, and I have the honor of serving as the Secretary of the Society's Steering Committee. I'm an associate at Faegre Baker Daniels and have been with this organization for just about 3 years now, although attending events here since really becoming a lawyer. Before we get started, I wanted to note a change up in our program. We're going to flip things around a little bit to accommodate some schedules. So instead of hearing from our Davis versus Bandemer panel, we're going to hear from the former practitioners of legislative redistricting. We won't call it gerrymandering yet. But before we do that, I want to recognize a man who is not here with us. It's our outgoing steering committee chair, Michael Blickman, who has been chair and head of the organization really since January 2011. He will be missed, but from what he tells us, he's not going far. So we look forward to seeing him back again at other events. And with that, I want to transition to welcoming and announcing the Society's incoming president and my colleague, Libby Shizniak. I believe I saw Libby. Libby's here. Libby is a round of applause. Libby is a partner at Faegre Baker Daniels in the government and regulatory group. But more importantly, for our purposes, she's a historian extraordinaire. She has written numerous articles for a website called historicindianapolis.com. Now, I'll confess, I don't check that site every day, but I have, and I do believe I first encountered Libby doing some Google searching on history in Indianapolis and have several times stumbled upon her excellent research. So I encourage you all to check it out if you're interested in articles about the history of Indianapolis. With that, I want to thank the patron sponsors of the Historical Society, without which this event would not be happening. So thank you to Faegre Baker Daniels, Ice Miller, Krieg DeVault, and Taft. For those of you who are here from other firms, there are ways you can join us as a sponsor of the organization and enjoy a number of benefits, including, as some of you know today, free attendance at next year's CLE. In that vein, I want to highlight our major accomplishment for the prior year. I think some of you know we've done films and books in the past. This year, our major accomplishment is contracting with the Indiana Historical Society to begin processing the personal papers of Judge William H. Steckler. This is a rather extensive project involving many, many boxes of material. This will be completed in the next year and really constitutes the core of what the Society does, which is preserving the history of the court. Upcoming goals include overhauling the court's museum, which is small right now, but an important part of the court's efforts at sharing its history with the public. The court is also in the process of hiring a training specialist and outreach coordinator to expand the public offerings, public educational offerings. And last but absolutely not least is Doria Lynch. I want to thank her for her tireless and inspirational efforts on behalf of preserving the court's history, which frankly would remain in boxes or behind paint without her efforts. So with that, unless someone has arrived, he's on his way. Okay, we are going to have a slightly different program that's in your papers, just reorganized some. I want to start out by introducing Professor Luis Fuentes-Rohr, who can join us at the table. LFR, as he's known to his students, is a professor, the Harry T. Ice Fellow at Indiana University Maurer School of Law, where he teaches and writes in the areas of civil rights and legal history. And more specifically important for today, he has an emphasis on constitutional law in the Reconstruction era and has a specialty in election law and redistricting. Several layers there. He has focused on the intersection of race and democratic theory as reflected in the law of democracy, including, for today, redistricting. Joining the professor is Chris Scanlon, a retired partner at Faegre Baker Daniels, where he specialized in business and commercial litigation. Chris was the chair of the firm's litigation group and was also on the district court's local rules committee. He was also president of the Seventh Circuit Bar Association from 2012 to 13. While president, he persuaded Chief Justice Roberts to come speak in Indianapolis as part of the association's annual meeting. He's also, most importantly, I think, the accomplished jazz drummer who can be found practicing regularly in Indianapolis at what I understand is an undisclosed location.
That's correct.
Turning to, I guess you call them our witnesses today. We're not putting them under oath, but we are in a courtroom. We are going to introduce Mr. John Gregg, who was a state representative in the Indiana House of Representatives from 1986 to 2002. He was the majority leader in the 90s, minority leader also in the 90s, and then Speaker of the House from 96 to 2002. Did I get all those dates? We cleared him in advance. In both 2012 and 2016, he was the Democratic nominee for governor of Indiana, is now a partner at Ice Miller in the public affairs practice group. On the other side of the aisle, we have John Keeler. He's a vice president and general counsel at Centaur Holdings. He served in the Indiana House of Representatives from 1982 to 1998. He was both chairman of both the Judiciary Committee and the Rules Committee. He was partner at Baker & Daniels from 1998 to 2009. And frankly, in doing some research last night for this event, I learned that from a Howey political report that he was a master strategist, the master strategist, in fact, during his tenure in the Indiana House. The clippings tell us that he had to personally deal with some of the redistricting issues that we'll be talking about today. Now, with that, why don't we start with allowing both our former representatives to give a brief background in addition to what I've already said, and then turn to their the time in the House when they participated in redistricting. So, John, do you want to lead us off? Because I know you have a hard stop.
You should never allow someone that sought office twice and wasn't successful the last two times to have confined in a room an audience. I mean, this is like heaven, you know? So, wow, I've only got 3 hours. I was not a member when the case was filed, but I became a member in 1986, and I can remember, of course, shortly came down after that, and the euphoria that hit the Democrats in the House at the time was the end of what we called the multi-member districts. We then won the election. We tied in 88. The Democrats in 1990, we elected 52 members, so we got to do the reapportionment, federal seats, and the redistricting for the state house seats. Then Speaker Mike Phillips put me in charge of the process, so I did it in 91, and then I had the pleasure of serving as Speaker in 01, where I was, I'm telling the truth, but I was very involved with it then also. And if you look at the results, I guess, from it, a couple of things. We picked up when the multi-member seats left Marion County, it went from where they had 15 legislators, 12 Republicans and 3 Democrats. We went up to 6 Democrats. We picked up a seat in Southern Lake County. We picked up a seat in Allen County. We went from having 1 representative Allen County to 2 Democrats. And so that was where we picked up. We thought we were going to pick up one in the southern part of the state in Evansville, but we're not successful. But we picked up 5 seats, really just with doing away with the multi-member districts. To tell you what they did to prepare us for this, myself and the technician, his name was David Dreyer, they sent us to Washington, D.C., and the Democrat National Committee gave us a schooling. They showed him how to use what was a state-of-the-art computer, which was about that big, and it moved about as quick as I run. And they locked me in a room with a bunch of other people and gave me keywords not to use when I was being interviewed and when I was testifying on behalf of the bill. None of our members asked questions. They were told not to ask questions. And there were certain words I was to use and not to use. My favorite one, and I see Ed Feigenbaum back there, and John may remember it, on the federal suit, the word we were to use was de minimis. And they wanted the same size. In Indiana, we had every congressional seat but one, the exact same number. The one that was in Winchester, Portland, south of Fort Wayne, had one more person. And we split precincts to get to do that. And we did much the same thing in 2000 and 2001. The technology was better. And the technology makes all the difference in the world when it comes to artfully drawing the seats.
My experience in the legislature began in 1982, so I was the beneficiary at that time of the multi-member districts in Marion County, having one of the seats in what was then House District 49, which was on the north side of Marion County, and really swung around through Pike and Lawrence townships. We just took for granted that those were the seats that they were, knowing that the litigation was pending, and expected nothing more than when it went to the Supreme Court and those districts were upheld. I think I would be remiss if I didn't mention at this point in time what a great job Bill Evans did on behalf of the Republican legislature. I mean, he was a true gentleman and a great lawyer, very humble, and just did a superior job. But so Daniel introduced us as practitioners of redistricting. I would consider myself to be a victim of redistricting, especially at John's hands, in the sense that, you know, fast forward the 1990 reapportionment, Democrats were in control, as John mentioned, and I was in this multi-member district that was broken up, and then, as was the case with several of us, we were put in districts with other Republicans and had to fight it out to see who would be the survivors. It's a really interesting process. I mean, from a judicial point of view, I mean, you look at it as one man, one vote, making sure that it's not racially imbalanced and those sorts of criteria. But from a legislator's perspective, it's very personal, and in some instances, John can probably talk better about this than I can, very, very petty among the people that are involved, not only in terms of wanting to gain a political advantage for their caucus or themselves, but also just the funniest little personal attributes of why people want their districts the way they are, and whether that's for their own benefit or they want to hurt somebody else. I mean, the reasons go on. And then finally, while not so much a federal issue, I had another opportunity where I was the victim of redistricting when I was the Marion County chairman, and we had worked very hard because under the state statutes, the Superior Court en banc is the one that redistricts the city county council. And I knew that was coming up, and we'd had a couple of these judicial elections where I forget exactly, but 15 of 16 or 17 of 18 were on the ballot, and worked very hard to make sure that Republicans won the court so that theoretically we could have a favorable redistricting of the city county council. And in that instance, again, being a victim, the Indiana Supreme Court chose, you know, on the eve of the election to set that ruling aside of the Superior Court that had redistricted, and then draw the maps themselves or itself. So that's a little bit about my background and experience.
Can I add something on the pettiness? I'll give you a couple of examples. And the ones in your own party are the worst because you were to take care of them. Mr. Keeler and his caucus basically knew we were going to take care of them. But they would come in and say, you don't understand, I have to have this precinct or this township because that's where my family was from, or that's where my great-grandfather went to church, or there used to be a 3-room schoolhouse. And it also went to Congress because former Congressman, pronounce it Byer or Booyer, the last time I saw him, which has been 10 years ago, there's no doubt in my mind he didn't vote for me. I know that when we redistricted in 01, that we had the audacity, I didn't know this, where we cut townships, his parents, who lived across the road from him, couldn't vote for him. So people remember things like this.
Can I say if
If you have questions for them, go forth. Otherwise, I may have a question or two.
just a quick comment. So first of all, what an honor to be in this room
with these huge figures. These are the things you read about, and it's just what I do most of my time, read about things. I don't do things, I read. I was telling my friend Jay, I just read and think, and I don't do. But don't. In fact, could you rewind that tape if you don't mind? So the two things they said that I want to think about with you out loud. One, you heard, the comment was, the computer moves as quickly as I run, which was pretty funny. I don't know how fast Mr. Gregg is, but I'm assuming he meant that as slow. And this is, if I'm wrong, I apologize. On that point, right, that's the problem today. Computers are not so slow anymore. In fact, they're too good. That's point one, and that's going to come up as we think about it, this problem moving forward. In fact, he's right when he says technology makes all the difference in the world. That's exactly right. The second point is about the process. You heard it's petty, it's personal. Question for us to think about is a question of process. Once we decide to do this, who should be, or what institution should be the one doing it? And why in the world will we let, and this is really a question, I'd love to hear from them. Why in the world would we let legislators do it? That is a question worth thinking about, especially with the first point. Computers are so good. So good, in fact, this is a point that's going to come up again. The expert who designed the districts in Wisconsin wrote a brief to the U.S. Supreme Court saying, you know, he didn't change his mind. He said, if either you stop me, I'm of course paraphrasing, either you stop me or this will not stop. In fact, it's too easy. And if you were to give him truth serum, he'd probably tell you, and I make way too much money. Be that as it may, the point is, right, we need ground rules, or we need to take it from them. So that, I guess that is my way of asking a loaded question. Or, is that right? Do you agree that should legislatures be doing this? Because we know, it's like there's articles writing about the foxes guarding the hen house. If you let them do it, they will do it. And then once computers get faster than Usain Bolt, then what happens? And if you don't know who Usain Bolt is, I can tell you afterwards.
Well, I think I have a pretty simple answer to that question, and that's because the Constitution, rests that job with the legislative branch of government. And to me, I don't know that there's much more that I can add unless, I want to have a constitutional amendment because I don't think that's right and proper anymore.
I'm in an awkward position being a member of a permanent minority party in Indiana who is literally the only person who ever benefited and got to do the reapportionment. I'll answer it with a scenario because being in a separate branch of government, my question to you would be, who are we going to let do it? I don't want the judges to do it. I don't think there's any such thing as an impartial panel in this day and age where everybody has an opinion. So I don't know who that impartial panel is, which is a deeper problem, I think, for the country. But I can tell you that in 91, 01, 11, it'll be the same in 21 with the technology. A Democrat drawing the map, the best they can draw it is where the Democrat would always have about 44 or 45 seats. We got up to 55 after the 90 election at one time. When the 94 landslide came, we dropped to 44, so my theory held. Out of the 20 years that we drew the maps, remember the Democrats held them 16 of those 20 years. We lost them in the landslide of 94, and we lost them in 2010. Really bad timing to lose an election in that. If I were a Republican or anybody with just a little bit of talent, I could draw the maps where the Republicans would never drop below 58 to 62 seats. And if I wanted to really have some thin margins and I had good candidates, I could see to it that there were always 65 to 68 Republicans. It's a factor of where we live. And then also one other thing that goes against what you're arguing, Professor. This is the map that was one of the handouts. Look at this map and it shows this old mark. If you follow what looks like southern Indiana here, I want you to go up and put Bloomington in southern Indiana and Park and Putnam counties. That's how we define southern Indiana when I was in the legislature. When I left in 2002, we actually had 23 legislators from there. Today there's 5. That's a change in demographics, not so much from the House. Trust me, I know that firsthand. If those people down there were still voting Democrat, you'd have clapped for me when I came in. I can see some of you don't get that, so I'll stifle the show. But I guess the one thing I would say is, my question back to you, who would you have do them that's fair and impartial in this day and age? Please.
The big move nationwide is independent districting commissions. Now, you may ask, fair enough, who would be in those commissions? Surely we can say it's hard to find those people, but surely we can find a bipartisan group of people to try to get at whatever is best for a given state. And of course, it's a loaded statement, I concede that point. But that, which is, by the way, this is a place or a way the country's moving, or many states are moving in this direction. To me, that's a better state of affairs, to have a body of bipartisan men and women and moving towards what they think is a better way to reflect the political interests of the state, of say, Indiana, of the given state. That versus a political body whose sole purpose, in fact, and I'm sure you know this, whole purpose is to exact political power, kind of like the case in North Carolina when they asked him, well, you 10 of 13, this is basically a purple state, 50-50. How did you end up with 10 of 13 seats? And the answer in open court was, because I couldn't draw 11. I don't know. I'll pause a second. Let it sink in. I don't know how that begins to be defensible. I don't know. Now, the point is well taken. How? No court, I get that. The Constitution, I get that too, of course, right? So then, of course, you'd have to go there and amend the Constitution. When I say who, right, I was talking like we the people, what should we do? Rather than more specifically, like, should we appoint ourselves here in this room somebody? I mean, that point well taken, both points are well taken. But I don't know how you defend, especially the point, in this day and age, we've become so tribalized, I don't even know. In fact, I don't know.
Well, getting back to a little history, and Ted and I will talk more about our case in a little bit. We did lose the issue of getting the map that had been drawn in 1981 thrown out as an unconstitutional gerrymander. But we did win the proposition for the first time that political gerrymandering was a justiciable constitutional issue. We challenged the multi-member districts particularly and focused on that particularly, and we didn't win in that case, but I think history shows that when they were eliminated, it made a more proportional representation based upon the geographic area for the Democrats. The Democrats gained seats that were closer to the ratio of the Democratic voting population within the area that had been composed with multi-member districts. And but we did establish the proposition that political gerrymandering was unconstitutional, possibly. So my question is, and you guys were both in the legislature after that decision came down and involved, I hear from John that it resulted in a language seminar run by the DNC, perhaps to guard against words that could be construed as a political gerrymander. But other than that, did it have any effect? Did the ruling that a political gerrymander is challengeable just like other kinds of gerrymanders, racial gerrymanders, unproportional voting rights, just numerically. Did we do anything? Did it have any effect? And if it did, what was the effect?
I'll take that, Chris. I think the simple answer is no.
Yeah.
The self-interest and...
Thanks, John.
Self-interest and the desire for your party to continue in control, I think, continue to be the predominant rationale behind these. And what the court decisions have done, I believe, besides just make it more difficult for legislatures, is set a set of rules that everybody tries to get around. And as John mentioned, and you alluded to, I mean, there are certain words you don't use and the like, but I think the simple answer is no. Everybody's still driven by that desire to not only keep their own seat, but to keep the majority.
Right.
We did, I would say there was, we were cognizant of pockets of African-American voters outside of the Marion County and Lake County area. There was one place in particular that we did try to follow some court guidelines, and it was interesting because where we would argue that the multi-member districts packed, where it diluted, we used the opposite argument of it, and in Allen County actually tried to create a minority district, and we won the district, but it was not a minority, represented by a minority.
Representative.
Yeah.
Mm-hmm.
Let me take a quick moment. We're not taking our full break here. We will in about 30 minutes, but I want to take the opportunity now to add to our panel as originally intended to introduce the Honorable Ted Boehm, retired Justice of the Indiana Supreme Court and past managing partner at Baker & Daniels. His list of accomplishments would take up too much time to go over, but to highlight a few, he was a law clerk for Chief Justice Earl Warren and general counsel for General Electric and Eli Lilly. He now arbitrates and mediates complex business cases across the street at Hoover Hull Turner, and we would welcome him to our panel. I understand he has at least one question that he's ready to go with, so.
I apologize, Ollie. I had it on my calendar for 2 o'clock, so I'm the source of the delay and also the disorder. I have several comments, if I may, on the whole situation. First of all, on the question of whether gerrymandering should be in the hands of the legislature, there are several states that have said the answer to that is no. And Arizona and California have adopted different forms of bipartisan plans that are in effect, that have definitely changed the electoral maps in those states. And to answer John Gregg's question, who would be on the panel that would do that? In those states, and it's done differently, and Iowa has yet a third approach to it. But if you have a statute that says draw the lines without regard to political data at all, draw them as in conformity to existing lines that have an independent meaning, such as a township line, a county line, a school district, so people understand where their districts are. They're not just arbitrary lines as a gerrymander typically produces. And don't consider the political makeup of the district at all. These panels do, in fact, follow those directions. The people who get appointed to them are generally people with some reputations and prestige in the state, and they don't want to compromise their own reputation, and they don't want to be challenged in court as having violated the statute in drawing their own maps, and so they do a good job. So it can definitely be done. The problem with having the legislature do it is manifold. First, it's the classic conflict of interest statute. The people who have the most to gain from a gerrymander are the people who will be kept in the committee chairs and the senior positions in the legislature in the majority party. They're the principal beneficiaries. In some ways, it's a game in which there are at most 150 winners and 6,300,000 losers, because you end up with a legislature that is essentially partisan because the primary election becomes the only meaningful election of the vast majority. And in a primary, the candidates run to the center of gravity of their parties, not to the center of gravity of the public at large. The result is a legislature with very few centrists, very few moderates, very few people who represent the largest single body, namely independents, people who would disclaim affiliation. It's also totally undemocratic because independents typically don't vote in the primary. In Indiana, they even have to withstand a challenge to supply an affidavit they intend to vote for the majority of the party in whose primary they want to vote. Now, that actually used to occur in the 60s. Some of you who are my age will remember that that kind of challenge could take place. It doesn't much today, but there are a lot of people who simply as a matter of principle will say, I don't want to affiliate myself with either one of these parties, and don't vote in primaries. They're disenfranchised. They get no vote in the selection of the legislature, no meaningful vote. You can go on and on and on about the ills of gerrymandering, but they are severe, and they really have produced what we have today is largely polarized, challenged, partisan legislatures. I've got a longer speech on that subject, but I'll stop now.
I don't disagree at all in any of that, and it makes it difficult. I would say out of the 100 House seats, there's maybe 6 or 7 that could be competitive if they had good candidates and well-funded, and that makes it real difficult if you are a Speaker Bosma or Minority Leader Gooden in recruiting people, because a lot of the ballots anymore get filled after the primary, and you're absolutely right on the polarization.
I want to step in here and ask a question here. Knowing that we're going to talk for about an hour after the break about the Davis versus Vandermark case, I want to get a sense from Speaker Gregg. Do you have a sense on whether the instructions given to you in D.C. were because of the litigation in that case? And if you don't mind bringing the mic a little bit closer.
I'm confident it was, and it was the educational process was really for the standpoint of knowing that, they would be watching, and it was to avoid litigation in the future, because we fully expected Mr. Keeler and Mr. Manweiler and their machine that they have here. No, we figured we'd end up in court, and we were more cognizant of it in '91 than we possibly were in '01, but '01 gave us a really tough challenge at the federal level because we lost a congressional seat. So we knew 2 people were going to be put together, and that made an interesting situation.
Okay. And I guess then for John, and do you recall whether or not there was a consideration to challenge that map that turned over your world in a way?
I do, and this is the litigation in this arena is not for the weak at heart or those that don't have much money. And to give you an example of just how expensive it can be.